How do you know the value of a patent?
Great question. If you want to have a monopoly, a patent would be very valuable if it gives you the right to stop your competitors from knocking off your product. In that case, you could place a high value on your patent. Patents can be analogous to a border you are creating. If the border is narrow, it will be easy to cross. If the border is broad, it will be hard to cross. Broad patents are definitely preferable over narrow ones because with a broad patent, your competition will need your help to cross the border. With a broad patent, it's like being a troll at a bridge, collecting money to pass.
All right. How do I get a patent?
The first step is for a patent attorney to prepare a patent application and file it with the Patent and Trademark Office in Washington, D.C. A patent application is an offer to the government to exchange a benefit to society for a monopoly. The benefit being an advancement of the state of the art. In this sense, it's like any other contract you make. The patent application must then be negotiated with the patent examiner. This negotiation process is called prosecution and can take several years.
Years?
Yes, years. After the prosecution is completed and the patent is granted, the inventor has a contract with the government. Because the invention has met the patentability requirements, the inventor now gets a monopoly on the invention.
Okay, I'm ready. Let's go. How much is this going to cost?
Before you get too far ahead of yourself, we need to determine if your invention has met all of the patentability requirements. Before filing an application, ask whether certain time limits have been strictly observed. The invention is novel and non-obvious. A way to make the invention work is described. Okay, so the first requirement is that certain time limits have been strictly observed. In the patent profession, we refer to these time limits as bar dates. So let's learn about bar dates.
You have the most beautiful blue eyes I've ever seen.
Well, they're brown, but that's okay. Let's get out of here. No, not that kind of bar date. We don't mean sleazy bar dates. Sorry for digression. What we meant was that a bar date is a point in time after which you can no longer apply for a patent. You lose your opportunity to play Monopoly. It's the date after which the buzzer sounds and you are out of the game. It's the date after which, even if you are close, you get no cigar. It's the bar date.
It's the worst kind of patent tragedy. And the worst part about bar dates is that inventors and business people create their own. That is, by their own actions and inactions, they cause the bar dates that preclude their even being allowed to apply for patent protection.
Do you mean we could have already done something that would prevent us from ever getting a patent on the wheel?
That's right.
What is it that we were not supposed to do?
There are 3 ways you can trigger a bar date. A bar date is triggered when a sufficient description of the invention is published, when there is an offer of the invention for sale, when there is public disclosure of the invention.